Hey everybody, welcome to another episode of Ask Me Anything. Let's get started on your questions. My parents are in their 80s, still paying their mortgage on our house. What is involved for me to pay off the mortgage and putting the title under my name so my parents do not have to worry about this anymore? This is a very easy question, and my gosh, isn't it generous of you to pay off the mortgage of your parents? I love that. That's probably every child's dream, is to make enough money where we can pay off our parents' mortgage. So the question comes down to who is the co-signer, who are the people that actually have the mortgage? Have you been paying the mortgage for your parents, or are they paying the mortgage? Either way, anybody can pay off a mortgage. The bank will always be happy to take your money, right? So if you want to pay off the mortgage, then go ahead. But just keep in mind, you will be making a gift to your parents. This is not something that's free. So there is a kind of gift tax that exists. When you give more than a certain amount of money every year to any individual, then there is a gift tax consequence. But don't worry, it's not that you have to pay taxes, neither the person receiving the gift. It's more that you have to let the IRS know, and they count it against your lifetime gift tax exclusion. So all of us right now across the United States, you can make a gift up to $15,000 per person each year. So if your parents' mortgage, for instance, right now is worth more than $15,000, then $15,000 of how much you pay is free, no tax, no consequence. Anything above that will be a gift that you're making to your parents, and this is not tax exempt. So what does that mean? That means you might have it count against your lifetime gift tax exclusion amount, which right now, that exclusion amount, meaning you can gift up to this amount of money without having to ever pay taxes or worry about it or tell anybody, is $11 million per person. Roughly. So obviously that's a lot because it's for your lifetime. So if it's not a substantial amount of money, maybe less than 100,000 that you're gifting, that's not bad. You can totally go ahead and do it, sign off that mortgage, and then your parents can transfer the home over to you after they have full title. The hard part is if your parents transfer the home to you before the mortgage is paid and nobody talks to the bank about this, there's an acceleration clause that the bank can trigger and foreclose on the home. They probably won't do that really quick. They'll probably call your parents and be like, yo, what's up? You just moved the home to someone else and you haven't finished paying this loan, and that someone else isn't beholden to this loan. So we're not happy, right? And obviously it doesn't matter because you're going to pay it all off anyways. But yeah, you can totally do that. And if your parents transfer the home to you, there shouldn't be a reassessment of property tax, at least not here in California, because it's a parent to child transfer, which is exempt. So I think you're just fine there. What's involved? Call the bank and tell them you want to pay off the loan. Step one. Second step, record a new deed from your parents' name over to yourself. There you go. But this kind of goes against my own advice that it's never good for parents to transfer property or gift property over to their kids. There's no property tax consequence of this. Your parents will have a gift tax consequence of the property transfer itself. It'll be less if you transfer the loan and the property over to you. But before I go down that rabbit hole, what I'm trying to say is it's better that you inherit the property instead of have them gifted to you. The reason for this is there is a cost basis. What was the price, the original purchase price of when you bought that house? If that price is a lot higher in market value today than when you originally bought it, then you have a large tax consequence that you're going to face when your parents transfer that to you and if you later sell the home. Instead, if you have your parents put it in a trust or maybe file a transfer on death deed, so they're holding on to the title, but they're using another legal tool, an estate plan, or some kind of deed that says you are the beneficiary of this home. It'll avoid court when they pass away, and it'll go directly to you. And this way, instead of them gifting it to you, you're inheriting it. And when you inherit property or any asset, the cost basis of that property jumps to the fair market value of that property at the time of death. So hopefully your parents they're in their 80s. I want to see them live to their hundreds. Make them centurions. Do it. But when they pass away and you finally inherit the home, the value of the home at the time of their death is what you're inheriting, not the original cost basis. So if you later sell it, huge tax rate. So give that consideration. Maybe the best thing you can do is tell your parents, set up a trust, help them pay off the mortgage so they don't have to worry about that payment. That's good. But instead of transferring title over to you, have them instead put the home in a trust and have it go to you when they pass. All right. And I'm happy to help you do that if you need it. Next question. I'm a surviving widow, a green card holder. I was married to my husband for 6.5 years, but nothing is bequeathed to my name. My husband forced me to sign a prenuptial agreement, which I believe is invalid. He has 3 children from prior marriages. Now I want to know my rights to the estate. I need to support my medications. I have no house and no income, not able to work due to my health condition, spinal arthritis, and continuing nerve pain. So it sounds like you are in a little financial squeeze right now because your husband has passed away. All right, well, first thing, are either of you collecting Social Security? You have spousal rights, okay? I don't know what those spousal rights are, if there's a difference between being a citizen, non-citizen, but you're a green card holder, and usually from what I've seen, if you're a resident or citizen or resident, you're a green card, then you can, you qualify for those spousal rights and marital deductions and all that kind of stuff. The hard part here is you haven't told me what kind of estate your husband has. Did he have a will? So did he not have a will? Did he have an estate plan, a trust? What happened? When you said nothing is bequeathed to your name, that tells me either you didn't hold any assets jointly, like not your home, not any bank accounts. It also tells me that maybe it sounds like husband had a will and he just didn't include you in it. Well, in California, your spousal right, if there are children, is about 1/2 to 1/3 of your husband's share of the community property. And remember, you're living in a community property state. So even though you're not a citizen, it doesn't matter. You both are married, you're in California, and so his income and the assets that he's accumulated during your marriage is community property. You might want to speak with a family law attorney to see what your rights are in terms of what assets he had. Even the assets that weren't titled into your name, still community property. What does that mean? 50% of the share of all of your husband's assets that you both have collected, all of your assets together that you both have collected throughout the years of your marriage, is 50% an interest that belongs to you. So even if it's not titled to your name, that doesn't mean you don't have an interest. And what needs to happen next is we need to see how are his assets titled, where are they collected, which assets did he obtain while you both were married, or with his income while you were married, which assets did he have prior to your marriage? That would be his separate property. And how does his will handle this? And even though his will might not bequeath something to you, you still have the interest in 50% if it is part of your community property share. Now, his community property share, well, he can do whatever he wants with it. And if he didn't include you, that was his prerogative, and that was something that should have been discussed. Now, your prenup agreement, yeah, it does come into play if it talks about what happens at the time of death. But if you believe it was invalid, hence you need a family law attorney, because yeah, prenup agreements can totally be torn up if they're not fair at all, or if they weren't executed properly. Okay, so if he forced you to sign it, if you were under duress to sign it, if he made any kind of threats that if you don't sign it, then I'm not going to do this and all that, yeah, that is all in your power to potentially invalidate that. You need to talk to a family law attorney. Third time I'm letting you know, family law attorney is what you need to look for. If you need help finding one, I have a good one. Let me know. I will connect you. All right, I think that's enough I can answer there. Next question. My aunt does not have any children and wants to leave her money to me. Yes, I want aunts like this. Come on, people, world. To my trust and not to spend more money. Okay, say she wants to leave money to you, to your trust, and not to spend more money on one of her own. So she doesn't want to do a trust herself. I have a trust for my children. Can she do this? Can someone leave, the real question. Can someone leave assets to a trust where they are not the grantor? Absolutely yes. Anyone can transfer money to any trust. It's that easy. Now, why would they do this? I don't know. That's their prerogative. That's the key word of today, it seems. But the way it would work is if your aunt ever wanted to leave, she could just on her bank account name a beneficiary, for example, and the beneficiary would be the current trustee of your children's trust. So if that's you, then she would just say, beneficiary is, I wouldn't even name yourself, just the children's trust, the name and date of the children's trust. And the bank is used to this. We do name trusts as beneficiaries on accounts, insurance policies, retirement accounts, all that kind of stuff. That's all it takes. And when she passes away, then it goes into their trust, and the terms of the trust for your children dictate how that money's to be held and used. Very easy. If this is a little confusing for you, then reach out to me. I'll be happy to help. Other than that, I think I answered everyone's questions. Easy peasy. All right, everybody, have a great day. Let's all be positive this week. The air is getting better. They went to the East Coast.